SJC-13144, Commonwealth v. Jerron, Perry.
Okay, Attorney Tenen, when you're ready.
Good morning, Your Honors. May it please the Court, Eric Tern on behalf of Jerron Perry. Your Honors, an order authorizing the government to obtain cell tower dump data of anyone in the general vicinity of a crime when there is no known suspect nor known phone number is simply a general warrant that contravenes society's expectations of privacy.
So no matter how serious the crime, no matter how many separate crimes there are, no matter how similar the crimes are, no matter how much probable cause that there is that a suspect would be discovered, no matter how distant the cell towers are from each other, and no matter how considerable the mitigation is, and no matter how unlikely the crime would be solved without the information, the government cannot, even with a warrant, ever have a cell tower done.
There is no convenience exception to the Fourth Amendment. There's no serious crime exception to the Fourth Amendment, or Article 14 for that matter.
Well, there sort of are, aren't there? Like, if there's an emergency, or there are some exceptions based on hot pursuit or based on life and death situations, so there are exceptions.
Those are exceptions that the court has said, in this situation, the search is reasonable.
All right, so that's what we want to look at here, right?
Correct.
Is the search reasonable?
So, correct.
But why isn't this, like, this is just a narrowing and an excluding process. It gets more and more narrow, doesn't it?
Actually, this broadens. So
It got broader.
it broadens, multiplied by thousands in this case. So you have precedence that says you can get CSLI data for an identified suspect, either the person or the phone number if you know it. And this broadens it to say we can get CSLI data for tens of thousands of unknown persons, unknown phone numbers, all but one who are innocent.
Once they do that, don't they do a further narrowing of the CSLI till they focus in on that number, or they just pull those numbers out of that first search?
When the government seeks a tower dump data, what they get are all of the phone numbers that were in the vicinity, the geographic vicinity of those towers. So there is no narrowing. It starts tremendously broad, and at that moment, that is the unconstitutional moment. That search, obtaining that data of all of those persons who are not guilty of anything, who are just in or near or at the scene of a crime, that's the unconstitutional part, even if they can later narrow the data.
Mr. Tenen, what do we do with our holdings in Estabrook and Augustine about whether or not something is a search in the safe harbor?
I didn't hear the last part. Whether something's a search?
Or the safe harbor, the 6 hour.
The safe harbor, certainly.
Safe harbor.
I think the best way to read that, there's a couple responses to that. Hopefully I can get them all out. The first is that Estabrook and Augustine admit that there's a subjective expectation, individual expectation of privacy. And so as I understand those cases, what they're saying is there's societal expectations. That's a sort of the second part of the expectations of privacy test. And society does not have an expectation of privacy in the government searching 6 hours or less of an individual known suspect's CSLI. This is not that. This is not, so you have to ask, what is society's expectation of privacy of the government searching not an individual known suspect's CSLI, but everyone at a...
But you're appropriately focused on your client's expectation of privacy. You can't raise the 50,000 others or 49,099 other people's expectation of privacy. So when you look at, well, I guess you're not arguing, or are you, that Estabrook and Augustine don't survive Carpenter? They were wrongly decided.
There is a question in terms of the 6 hour rule, how much of that, if any, survives Carpenter, and so that is up in the air. Okay. And again, in response to your question, there's two parts to it. So the first part I would argue is...
And I should have just let you finish, but go ahead.
The first part is what is society's expectations of privacy? And we're talking about whether something's a search in the constitutional sense. I would say that when the court has to decide that, what is society's expectations of privacy, it does have to consider not just that I am the counsel on behalf of the person raising the issue, But what is the government doing, and what society's expectations as to what the government is doing to determine whether it's a search in the constitutional sense? The second part of that answer, separate from that, is does the 6-hour rule, what does it mean, and does it survive Carpenter? And my response to that, so different from the sort of constitutional question, what did this court mean when it said 6 hours? I would argue the only plausible reading of that is this court was trying to establish a bright line rule, and that bright line rule is 6 continuous hours. So if this court meant something different, it meant, no, it's just whatever 360 minutes the government wants to use, it's not creating a bright line rule, because now the government can, for 10 minutes for 36 days, look for CSLI data, because that's less than 6 hours, or 5 minutes over 72 days, or 1 minute over 360 days, right? The 6-hour rule in that sense eviscerates, because it starts to create the kind of data gathering that implicates the mosaic theory. The court was trying to say, we are saying there is a small sliver of time in which there is no expectation of privacy, but once you start splitting up that time over days and months, you lose that narrow window.
So I think what we wrote in either Estabrook and Augustine, I conflate them, is that when we have a CSLI, there's a murder investigation.
Yes.
And we have a suspect, John Doe. And let's find out where John Doe was for 6 hours, around the time of the crime. We can either eliminate him as a suspect or move on to someone else, or build our case on him. But either way, when we do our 6-hour snapshot of Mr. Doe, there's no expectation of privacy in his movements for just that particular 6-hour period.
I believe that's right, and as I interpret that, that is a 6 continuous hour rule, not meaning not requiring a probable cause warrant.
So you're saying if you slice up that 6 hours, it becomes problematic?
Yes, because the intent, as I understand Estabrook and Augustine, was there's no expectation of privacy in this very narrow time of window. And when you start to slice it up, you expand that narrow time of window to get to the point where you are gathering data that begins to paint a pattern, and that's where you start to, now it blends into the other argument, that's when you start to contravene expectations of privacy that require probable cause warrants. So the 6-hour continuous rule is a clean rule, and it's easy to apply, but when you split it up, it doesn't become a clean rule. It goes beyond expectations of privacy requiring a probable cause warrant.
I'm sorry, you've answered my question. Thank you, Mr. Tanner.
Thank you.
Don't you have to look and see if those less than 6 hours do in fact create a mosaic?
I think that would not be a bright line rule that this court was trying to create. So a bright line rule is 6 continuous hours. If you say, no, what we meant was any amount of less than 6 hours that doesn't create a pattern, then you do not have a bright line rule. And now you are doing the kinds of balancing acts that, or the Commonwealth is not giving guidance as to, are we asking for enough or not enough data that doesn't create a pattern, or does create a pattern that we need a probable cause warrant. So it doesn't create that rule if that's what the intention was.
I'm with you up to the point. I'm with you that I think it may be a search, but the judge finds there is probable cause here, and it's particularized, right? And why, isn't he right? Go ahead.
Sure, sorry. Obviously, I disagree. So if it's a search in the constitutional sense, right, then the question is...
You agree with that part of it?
So you need a probable cause warrant. Was there particularity? Was there nexus?
Right.
2 different questions.
Right. Will it produce, is it probable that this is going to produce relevant evidence?
Right.
Here? Yeah, go ahead.
So to take those individually, if I may. So particularity. This is akin to the prohibition against an all-person warrant, an all-building warrant.
I find that completely, I don't look at this as a general warrant. This is not allowing the police to go rummaging in anyone's house whenever they want. This is a very narrow, they're looking for numbers that are, they're looking for, basically telephone numbers, hitting off the CSLI towers for very short periods of time. And they're looking to intersect the same, find that, filter it out so that the same numbers are produced. It doesn't seem like a general warrant to me. It seems like it's very narrow and specific and smart.
So what particularity does is assures that the government, when they conduct that search, does not search innocent persons. So for example, the reason you don't have an all-person warrant is because we know that if you go to this home to search everyone there, unless we have probable cause to search everyone there, it's invalid. If I know that someone is...
But innocent people can end up being caught up in something, correct? I mean, we don't have that sort of innocent, non-innocent divide. We have whether this is going to produce relevant information.
If you agree it's a search, then what you agree is that when the government obtains this data, they are conducting searches of everyone. Every phone number is searched,
You
every
want it to
person
be
is a search.
particularized to a particular person. That's not my understanding of the way either the Fourth Amendment or Article 14 works.
So again, look at an all-person warrant that this court has said and the Supreme Court has said, those kinds of warrants are only valid if every person, if you know that where you are going to search all persons, there's probable cause to search every person. So it is an individual, it does require the probable cause for each person being sought, or an all-building warrant. If you have information that there
If you've got
is...
probable cause to search a place, even though you don't know who's in it,
So
you get to search the place, and innocent people may be in it. You know, the girlfriend of the person who's ultimately dealing the drugs may be there, right?
So I think the better analogy, again, think of an all-building warrant. So for example, the government might have, maybe they're conducting surveillance and they have information that there is drug transactions coming out of a place. If that place is a single-family home, then it's particular enough to say, okay, we're going to get a warrant for that single-family home.
Yeah, but
If
what-
that place is, the person is walking into a 25-unit apartment building, you cannot get a warrant to search every unit in that 25
But
unit,
let's go back to
building.
Justice Kafker's original question, which was, you've got a single-family home and you've got people in there that are not criminal or not subject to the warrant. They're still affected by this.
As I understand particularity, it's that's not an all-person warrant, right? That's to search the place, not the people there.
Okay, well, what if it was an all-person present warrant?
Then you would have to know that there is probable cause that every person who you're going to come in contact with in that house, or sorry, that there is probable cause
That
for every
makes it
person.
a bad analogy for this case, right?
I'm sorry, Your Honor.
That would make it not a good analogy for this case.
I don't think it's apt. I think the better analogy is we are searching, it's like searching, you know that there is a drug transaction in this apartment building, but you don't know which unit. You cannot get a warrant for all that. Just like,
What if I decide I'm going to sit at the corner of the road and collect all the license plate numbers that go down the street one day, and then I'm going to do it again the next day, and I'm going to see who's consistently showing up? That would be fine, wouldn't it?
so, like this court talked about that in, I think it's McCarthy, I get the names wrong, I'm sorry. Thank you, Jessica, yeah. In McCarthy. So the issue there is that data gathering so much so as to be a search in the constitutional sense or not. And when you're asking me about particularity and nexus, we've already answered that question, and we're moving on to whether the warrant to get that data is particular or has a nexus, or and has a nexus, I should say.
So it doesn't matter.
If that goes to whether it's a search in the
Whether it's a
constitutional
search,
sense.
And we agree it's a search.
So if you agree it's a search, then we're on to did this order have particularity and nexus to
But
comply
why-
with the warrant?
But what they're looking for in this case, the particularity and nexus goes to particularity of phones and location. I mean, it's not, that's the nexus and the particularity. It's not like, give me everybody all over the state. It's a drawn circle, it's a narrowed area.
Sure, I don't think it's quite that simple. I think, again, when we talk about particularity, we're talking about crafting the warrant in such a way that you're only searching for or searching people or places for which you have probable cause. So it's not that we have narrowed the geographic zone to Dorchester, not
things,
Massachusetts.
right?
I'm sorry, Your Honor.
Or things.
Whatever it is you're
So
searching.
the thing that is being particularly described in these warrants is the phone number. No, because we know the location, we know the window of time, and we're just looking for the thing, that number that matches across each one of these 6.
What we're not particular to, so put it this way, Your Honor, or I would put it this way. So it may be that we know there's a suspect and there's a crime, and so when we get this data, we know that we will have probable cause for that phone number, but we also know that we're not going to have probable cause for the tens of thousands of phone numbers that come with that. And that is what makes a general warrant. When you are when you have a warrant to search a person or a place or a thing that you do not have probable cause for, even though you might have for some subset of that. So I have probable cause for one person in this house, but not all persons. For one unit in this building, but not all buildings. So in the CSLI case, for one person CSLI, but not the 49,999 other CSLIs that this warrant is going to bring to me.
Well, the CSLI cases talk about not just or lead to a suspect, but information concerning a crime. But just put that aside for a moment as it relates to particularity here. We've got, I don't have it exactly right, 5 armed robberies while masked, 1 attempted armed robbery with mask in conjunction with a murder.
6 total, yes.
Yeah, and you've got a limited amount of time on each side of the alleged event. That suggests a level of particularity. And what you're bringing up, and Justice Graziano and others have talked about the constitutional rights being particular to an individual. Your argument seems to be, well, what about all these other phone numbers, the raw data of all these other phone numbers? Don't we have to take into account issues like the ACLU brought up? I know they agree with your argument, but brought up about minimization. For instance, in Commonwealth versus Yusuf, in the body cam case, it's clear, okay, when you go into the home, there's certain observations that are captured, but don't go back and start looking through this raw data.
Right.
There's just minimization infused into the doctrine.
So there can be, and if I can take a moment to address that, I know my time's up, but so the ACLU talks about that in the context of the Berger case, and I do think it's helpful to look at that, but to understand very clearly, Berger was a Supreme Court case about eavesdropping and wiretapping. And so what the court said is, what they did here was unconstitutional. End of sentence. If, however, these procedures were to be put in place that minimize this, then that might not be unconstitutional. And that later became the eavesdropping or the wiretapping statute that they said, okay, now that you have put these in place, it's not unconstitutional for these various reasons that you said. So to come back to this case, none of that minimization was done here. So if this court thinks there is a way to minimize these kinds of warrants to make it so that it's not unconstitutional, I'm agnostic on that, I really am, but that doesn't save this case because none of that was in place here.
Okay, any other questions?
Can I ask one last question?
Of course.
So the Google map cases, are you familiar with those?
Geofence cases?
Yeah, the
yes,
geofence.
a little bit, Your Honor.
So in the geofence cases, Google has its own sort of protocol for how to filter out numbers, and should we be considering something like what they do?
I don't know if you can, in the sense that, as I understand it, and I might be wrong about this, that Google has the technology to do that. So I don't know if you could go to T-Mobile, for example, and say, we only want X, Y, and Z the way Google gives it to us.
Well, from what I understand, they break it into steps, that the police won't get all the numbers. They don't get that giant drop of everybody who was using a Google map or whatever it is at the time, but rather there are multiple steps so that the police only get the sort of end product. Would that be something that we could consider doing?
Maybe I don't know enough, or maybe I misunderstand it. What I understand about a geofence warrant is that it's not just CSLI. So for example, there's GPS and there's other things that allow them to narrow down.
Right.
I don't think it allows them to say, this is the one person you're looking for. So a geofence warrant might say, look, if you are talking about a 2-block radius, we can give you that, as opposed to a cell tower that gives you a much bigger geographic zone.
What I'm asking is, and again, I'm not sure the technology exists for this, but if instead of, I mean, you talk about the 54,000 people
Yes.
whose phone numbers got dropped off at the police. If they were only allowed to produce
I see.
when there was a nexus, meaning so that you're really limiting it to the people who were in the 5 locations where the robberies were, as opposed to 54,000 people.
I understand.
Would
So,
that be better?
so I think short answer is, of course, it would be better. So if the technology existed, for example, and it may one day, and maybe it's Google's, I'm not sure. So for example, I thought of maybe there's a nighttime warehouse robbery where no one should be there except people who are robbing it. If you had the technology to say, we can tell you what cell phones were in that warehouse and nowhere else, you have met particularity. You would still have to show nexus to show that there's information that those persons had cell phones, but yes, I think that solves the particularity problem if the technology exists. Obviously, it's not in this case. I'm not sure if geofence warrants are there yet, but they might be one day.
Okay, thank you.
Thank you.
Attorney Campbell.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is Jennifer Hickman, who's the trial prosecutor in this case. I would also like to acknowledge the victim's family who's watching over the webcast. We ask you today to uphold the denial of the defendant's motion to suppress. I think I'll start with what the Commonwealth specifically is asking this court to do, and there are three things we are asking this court to do. The first is to formally abandon the standing analysis. The second is to hold that a search warrant is not required for an aggregate of 6 hours or less of data that's collected from a cell tower dump. And the third is to reaffirm the premise that cell phones are indispensable to everyday life and people are using them and they're turned on. I'll start with the first topic that the Commonwealth is asking for, and
Actually, counsel, if you wouldn't mind, may I have you invert your order, because this is the problem that I have most with this case. And even Carpenter, to be quite honest with you, is this premise that at the motion to suppress part, the government gets to pass first base without any showing whatsoever that a cell phone was at all part of this crime. And, you know, looking at the trial court judge's decision, and that was parroted, or I should say was also repeated in Carpenter, that there's just this notion that everybody has cell phones, everybody has them on, and all of this data is being collected. And in this case, I know that you heard Justice Lowy list all of the really important things about these crimes.
correct.
But nowhere at all, other than just this bald speculation of the affiant, that everybody carries cell phones. So that's why we want this data dump. We have no information whatsoever that the person that we allege committed all of these crimes had a cell phone. We're just going to presume that he did, and that it was being utilized, or that it was emanating all of this information even while just passively on. That's the part that really bugs me. Can you help me understand how that's okay?
I can try. And I'll start with the probable cause standard itself, not that, I mean, we argue that this isn't a search in the constitutional sense, but looking at the probable cause standard itself, you can look at the practicalities of everyday life and common sense inferences that you can draw from those practicalities. In cases like, I think it goes prior to Carpenter, right? I think if you look at a case like Dorless or Onyx White, the cell phone search cases, they recognize that cell phones are indispensable to everyday life. Now, whether that is, and when they do so, they cite certain studies. Specifically, there's a CITA, I don't know if it's called CETA, but CITA. There's also a number of congressional studies in which prior to the Trump administration, so prior to 2016, there was a federal law which required cellular phone companies to report certain statistics and data, which was compiled into a report. What that showed was the number of individuals who did have cell phone, and at least as it could capture data as to the cell phones and their usage.
And Chief Justice Roberts pointed to that there were more cell phones for even the members of the population, right? That they were,
Right.
okay, I get all of that, sure. But I still have the problem saying that just because statistically that may be so, the fact that we have no information whatsoever means that we can request all of these and begin the process of trying to mine whether or not there are any common denominators to all of these.
So I think that gets to what the Fourth Amendment in Article 14, what it lets you draw inferences from. And I think if you look at everyday life, if you look at and says there are more cell phones than there are than people, then it is a reasonable and appropriate inference to draw that people do have cell phones. Insofar as the reservation and report, which I know Your Honor did, ask for specific statistics to support that they were on and being used, I was able to find sources which do support that people generally, and a majority of people carry their cell phones with them, which would support that it would use their location, that they are turned on. I think sort of, if you look at, specifically Apple did a study of their users, which everybody knows the proliferation of smartphones and iPhones, so I think it's a good snapshot of what you're asking about, that they unlocked their phones 80 times a day, which amounts to about 6 to 7 times per hour if you account for an amount of time an average person would sleep. So I think if you look at those specific types of facts, it gets you there. It gets you there. Now, I would say that because of that,
We've also said it in a bunch of our own cases, that it's an indispensable.
Yeah.
Correct.
So, and also, wasn't there evidence that there was a second driver here? So this isn't, completely sort of speculation that he's communicating with somebody.
It's not. I think, if you're asking for what underlies coming to that conclusion in the first place, I think it's supported. And I think that this court should reaffirm and support that, because the probable cause standard recognizes that you can point to common things that happen in everyday life, because what we're talking about is probable cause, which is probably, you do have to have a substantial basis to believe, and I believe that there is a substantial basis to believe based on the sources that this court has historically cited and the sources that I cite in my brief.
Ms. Campbell, I know you've listed 3 things, and we're only at number 1.
We're at 3, but yeah, yes.
And you haven't even gotten past indispensable to everyday life yet.
Correct.
But one thing I've been thinking about, Justice Kafka's right, we said even in Almanar that it's indispensable part of daily life and exists almost as a permanent attachment to our bodies. And that's the whole reason that we have all these cases where we want to be able to protect individual liberty as technology evolves.
Correct.
But what sort of I've been thinking about, going on Justice George's point, is what about all these innocent people? Isn't there going to be a point in time where that anyone who's thinking through a crime is going to shut off the phone, and the only people you're going to get are innocent people?
So here's what I have to say about that. I think as to the innocent people, and I would point to McCarthy for that, specifically page 508, is that the Fourth Amendment in Article 14 cases must be decided on the facts of each case, not by extravagant generalizations. The court has never held that potential as opposed to actual invasions of privacy constitute searches for purposes of the Fourth Amendment. And you may be right. What you're talking about are people that their Fourth Amendment rights haven't been implicated, right? Because they're not charged with a crime. I don't think that the Fourth Amendment or Article 14 provides a remedy to that. That's not saying that there isn't a legal remedy, but when you look at what the Fourth Amendment in Article 14 is designed to do, it's designed to protect individual personal rights, not rights wholesale of large of 50,000 people. So a good example, I think, sort of legally how that could happen is if you think about your toll reader in your car, there's a statute that says if the government wants to get that type of information, they have to get a search warrant. So there certainly are other legal avenues by which you could try to mitigate or minimize sort of invasions of privacy that happen to innocent people. That being said, I think it's important to look at the type of data that was requested and obtained in this case. That's not to say the ends justify the means, but it's always difficult in these type of cases where we're talking about data generally to sort of paint a picture of what it actually is. And when you look at it, it's the location of the cell tower which was connected to, and it's phone numbers, and it's the type of message. I hear what you're saying, Justice Lowy, and I think that the mosaic theory is trying to get that balance, right? It's trying to look at the usefulness of these electronic surveillance tools, is recognizing that there needs to be a balance, but it also is guarding against the power of technology to shrink the realm of guaranteed privacy. And I think it's that realm of guaranteed privacy that's important to look at, because look at the data that was collected in this case, as this court should do, and look at historically whether that type of information would be offered to any protections. And I say that it wouldn't. You know, locations historically so far, even if you look at it under the mosaic theory.
But people don't have an expectation that, I mean, they do have an expectation that the police aren't pinging them and trying to figure out whether they're at the, I mean, I find it hard to say this isn't a search. I don't think everyone thinks, oh, I had my phone on and I'm near the location of this place. Suddenly I'm in the realm of suspects. So I'm bothered by that. I understand this was localized, and that's why I'm interested in the geofence analogy, which doesn't give the cops the information until you've narrowed it down to somebody who actually might be a suspect. The idea that 52,000 people are potential suspects seems a little much.
But I disagree that 52,000 people are potential suspects, right? Because
the police are looking, I mean, they're not targets at this point, but.
They're not.
But I don't think, doesn't society have an objective expectation that you're not going to be swept into the police search this way without some more control?
Well, my answer to that is twofold, right? The first is, if you look at Augustine and the cases going on from Augustine, but I think Chief Justice Gantt's dissent in Augustine really describes this balancing that has to go on well, where it talks about the reasonable expectation of privacy that exists when we're talking about electronic surveillance, which I'm not sure that this does survey and as it reveals location, but it's not qualitatively the same type of surveillance. But he speaks about you know, drawing that durational line and looking at what is collected, that the reasonable expectation of privacy is that, and this is under Article 14, a person may reasonably be subjected to extended electronic surveillance by the government targeted at his movement. So it is the extended nature of that.
Does all that survive Carpenter?
All of that does survive Carpenter. I would point the court to page 2217, note 3, which specifically states that there is some duration. It is extremely limited, and they're talking about the duration which was requested in Carpenter, and it need not decide whether there is a limited period for which the government may obtain an individual's historic CSLI free from Fourth Amendment scrutiny.
Does that, as Mr. Tennant points out, survive being sliced and diced into 6 different episodes?
I believe it does. I believe it does. I believe it does because if you apply the mosaic theory, which this court should because it's involving the electronic collection of data, but when you apply the mosaic theory, what you're looking at is the points that are revealed. I think it's similar, and this is an answer to your question too, Justice Kafker, about innocent people being swept up in this, you know, the surveillance that's going on. If you look at a case like McCarthy, every car that's going over the bridge, their license plate is being recorded. So you don't say we can't look for this license plate just because all these other license plates were collected. The same is true if you look at a case like Mora, which is poll cam cases. Everybody that walks by the view of that camera is getting recorded. You don't say, you know, for the poll cameras that are in public places that the government can't obtain it because other innocent people may be walking by. That's where I disagree too with my brother's, and I'm skipping around here, but I want to make sure that I make this point, argument about particularity, because particularity has nothing to do with innocent people. Particularity has to do with defining the limits and scope of the search. And looking here, the limits and the scope of the search are clearly defined. Now, that's not to say, again, that there isn't some other legal remedy which may be applied to people who do not wish to have this type of information revealed to the government, but I don't believe the remedy is Article 14 or the Fourth Amendment. Now, to get to your answer at...
I mean, we can make a refinement of this apply prospectively. So, because, I mean, we're sort of, just what Justice Lowy says, we're sort of keeping up with the criminals are getting smarter, the police are getting smarter. There's sort of a constant changing of the game here, but I don't see why the police get all this information. If there's a way of limiting what the police get to the targeted person, Wouldn't you want that?
So my answer to that is, we don't have the record to do that in this case. We don't have the record to do this in this case, and I can tell you, speaking outside the record in my experience with
I mean, if Google can do it, I'm not sure why the government, why the telecommunication companies can't do it.
Your Honor, all I can say is you would be surprised what you get back when you send, even when you're getting a call detail record, an administrative subpoena. It is extremely difficult in my experience sometimes to deal with the telephone companies and how they keep or sort of disseminate this information. So I hear what you're saying, it's not on this record, and I would say, looking at it here, and I think that this is important when you look at the burdens in a motion to suppress, it is the defendant's burden to prove that his reasonable expectation of privacy was intruded upon. Looking at the data that was collected, which I think is critical under the Mosaic theory and under any principle, the defendant has not done that here, because you only, with locational data, gain an expectation of privacy if it reveals the intricacies and private associations, private things that happen in your life. And there's absolutely no showing on this record that any of that happened here. I mean, and the best
How about where you go?
Where you go, you only have an expectation of privacy in where you go if the whole picture that is captured by, think of the Mosaic theory, every single tile is something that you wouldn't necessarily get. I don't think that there is that showing here because of the limited duration. We have that this person was hitting off this cell tower, but we don't even have movement as you do in some of these cases. So I just think if you look at it under the Mosaic theory that it doesn't rise to that level. Now I want to hit my first point, which is formally abandoning the standing. And
I'm sorry, before you go to the first point, on your second point, which
Correct.
you talked about in the 6 hours
yes.
issue, and this goes to a lot of questions that you've already discussed, but when you talk about the Mosaic theory, what about when the 6 hours are broken up and you look and over the course of 4 hours you see that the person was at this political event or at this other association 6 times? So the question that Ms. Tanner raised about breaking up the time, could the 6 hours mean 6 continuous hours from Augustine to Isidore?
So I think how you should look at it, I think there is a recognition that there is some limited period of time in which individuals don't have an expectation of privacy in because the picture that it reveals is not big enough. I think the Mora and McCarthy have really good language as to this question. Mora says whether the surveillance was so targeted and extensive in that the data it generated in the aggregate exposed otherwise unknowable details of a person's life. McCarthy says the analysis should focus ultimately on the extent to which a substantial picture of the defendant's movements are revealed by surveillance. I don't think that 6 hours, whether you look at it as a continuous 6 hours or whether you look at it up as a broken up piece by piece, 6 hours gets you there. But even so, even if this court were to say, okay, maybe we should look at it at a case-by-case basis, here it would be the defendant's burden to prove that the electronic surveillance in this instance did, and there is absolutely nothing on this record to show.
Counsel, can I ask you to address opposing counsel's point regarding the bright line rule? I mean, the whole reason the 6 hours was set forth was to create this bright line rule. Now, if I start allowing 6 hours from whatever day, arguably the police could say, well, let's see if Mr. Smith is home at 4 a.m. All right, let's monitor the cell tower closest to his home for 10 minutes. And then on Sundays at 10 a.m., let's see if he's at the Catholic Church and do that for another 10 minutes. And so I can start painting a really good mosaic picture of Mr. Smith if the rule suddenly becomes 6 hours from wherever, as opposed to the bright line of 6 continuous hours. Can I ask you to address that?
Certainly. So again, I don't, looking at Augustine itself and looking at Estabrook, I don't see the word continuous in there, so that's my first response. The second is that may be so, but on the facts of this case, that showing hasn't been made. So it could be that an
So
individual.
if we wanted to stick with a bright line rule, that you would agree that the continuousness would be important, because if you allow the police just to say, okay, 6 hours in Justice Wendland's life, whatever 6 hours you may choose, you can choose specific hours and figure out where I am and start painting a picture of Justice Wendland's life.
And that may be so.
Yeah.
And that may be so. I would say that it would be.
It may not have happened here. I'm just
It-
saying, in
yeah.
general, if we wanted to issue a bright line rule, which is why in Estabrook we said 6 hours.
Correct.
Or in Augustine, it starts getting into a slippery slope if I let you break it up.
It may. I would say you need not reach that question here because it is not on the record here. And I would say that if a defendant wishes to make that argument, and it could be in certain instances that they could show, though this bright line rule exists, look here, this mosaic that we're talking about, these unknowable details of personal life, that's what happened here.
Right, and so that would defeat the whole point of a 6-hour rule, is if it's case by case, then, you know, why delineate this rule?
It would. I would say if you look at Augustine, in a footnote is where they talk about a limited duration. They pick 6 hours. If you look at Chief Justice Gant's dissent, he talks about figuring out some sort of duration for which there wouldn't be, but really this balancing test. I would say that, you know, where the mosaic theory has been more developed here and talks about the development of the points and looking at these points and looking at the picture that the points, that the overall big picture that the points creates, you know, it wouldn't be dispositive to this case and it wouldn't matter.
Thank you.
Would you go on to the first point?
Thank you. I will happily go on to the first point. As this court, as Justice Seifer wrote in her concurrence in Delgado Rivera, I think it is time for this court to revisit the standing issue as a separate analysis. I don't believe, if you even look at Commonwealth v. Amendola, which adopted the separate standing analysis in 1990, even in that case, it doesn't make much sense. They find that the defendant has standing to challenge, yet they remand it for the question of reasonable expectation of privacy, whether he had a subjective expectation of privacy in the trunk. So the dispositive factor is this expectation of privacy. I think it gets even more complicated when we're talking about electronic data, such in searches that happen and continue to happen with more frequency here, because if you look at this traditional standing analysis, which looks at whether the person was present or whether the person has a substantial possessory interest in the item searched or the place searched or the item seized, it gets really convoluted and complicated to try to understand. I think it has only gotten more complicated post the announcement of adopting it in 1990, specifically if you look at a case like Mubdi, in which, you know, they discuss Amendola, they then turn to reasonable expectation of privacy. They say it's the defendant's burden to prove that someone has a reasonable expectation of privacy. They cite to the Carter case, which expressly disavows that very notion. But even more so than that, if you look at this idea of an objective somebody, it's against the very text of the Fourth Amendment in Article 14, which talk about the right of people to be secure in their persons, houses,
My
papers, and
understanding
effects.
is the Fourth Amendment and Article 14 are personal rights.
They are personal, and you know, the text of Article 14 and the Fourth Amendment support that. Look at Article 14, they see searches and seizures of his person, his houses, his papers, and his possessions. So it was always meant to be personal to that person exerting their rights, which I think is important here when we can't go down and look at the 50,000 other people. We have to look at the defendant himself and his privacy interests. So thank you for letting me get to my first point, but I ask that this court formally abandon this standing.
Thank you.
Thank you.
Thank you.